Just to remind you that this meeting will be broadcast online and throughout Parliament buildings, and welcome anybody who's watching online today. So if you can ensure your mobile phones are muted, and if you're content, we will proceed with the agenda. So we have not received any apologies. However, we are aware that Anya is running slightly late, so she will be joining in due course. Do members have any declarations of interest to declare? Go ahead, please.
I'll just declare there's a matter of correspondence there from the Committee for Communities, so
yes.
Just to say I'm a member of that committee.
Okay, thank you. Noted, thank you. Okay, so chairperson's business. So there are no items this week, members. So draft minutes, you'll find these on pages 9 to 14 of your pack, and if you're content, I will go ahead and sign them. Content? Okay, thank you. Okay, so matters arising. So following on from the written briefing on the TO budget last week, departmental officials will attend the committee next week to speak to us on our queries on the budget. And just for information, the Finance Committee has indicated they're content to accept our response to the budget in the coming weeks to allow us to have that briefing from the departmental officials. Okay, so we're going to move on to item 6. This is the Northern Ireland Climate Change Commissioner Regulations, Northern Ireland 2024, and we're going to receive oral evidence from the department. You'll find the clerk's brief on pages 17 to 19, the draft statutory rule on pages 22 to 27, and the explanatory memorandum on pages 28 to 31. So just to remind you, members, that this SR will allow for the Executive Office to establish an independent office to be known as the Northern Ireland Climate Commissioner, and to allow the NICC to have the following functions: to oversee and report on the exercise of functions of Northern Ireland departments under the Act, provide advice and make recommendations to the Northern Ireland departments on the operations of the Act, undertake or commission research concerning the operations of the Act, monitor the implementation of climate action plans and sectoral policies, and publish reports, advice and recommendations and any relevant information relating to the operations of the Act. So just to advise, the proposed statutory rule is to be subject to the draft affirmative resolution procedure before the Assembly, and this means that it should not be made until laid in draft and approved by the Assembly. So just to also be advised, the Examiner of Statutory Rule has not yet reported on the rule, and the Examiner hopes to report on this rule by Friday of this week, Friday 21st of March. Once the Examiner has reported, the committee may wish to consider formally whether it is content with the statute rule as drafted. So welcome to the meeting today. So we have Colin Moffat, who's Director of Civil Contingencies Division in the Executive Office. So thank you. I'm just seeking agreement of members that we ask Hansard to record. Okay. Okay, so would you like to go ahead and...
Of course.
Thank you.
Thanks, Chair, and thanks, members, for the invite to be here today. I'm quite conscious of time. I think there's only 20 minutes for this session, so I'm going to try and keep my opening remarks brief and leave plenty of time for questions if we get there. Okay, so the first thing to say is it's important to set out that these regulations are being brought forward to deliver on a statutory requirement placed on TEO by the 2022 Climate Change Act. Members will be familiar that the kind of headline requirement of the Act that everyone's familiar with is that all departments must make efforts to achieve net zero by 2050. But the Act has also placed a number of specific requirements on a select number of departments. You'll also recall that the requirement to establish a Climate Commissioner here was not a feature of the Climate Change No. 2 bill when introduced. Instead, it was added by way of amendments as the bill passed through the Assembly. It is Section 50 of the Act which has placed this requirement on TEO. Section 50 is quite brief. It includes only 5 clauses. Just to help provide some context for members today, I'll go through those 5 clauses just very quickly. So the first of those clauses requires TEO to establish the independent office known as the Northern Ireland Climate Commissioner, and it specifically notes this is to be achieved by regulations. Clause 2 states the functions are to oversee and report on the operations of the Act. Clause 3 lists a number of provisions which may be included in the regulations and one which must be included in the regulations. The one which must is that we must make provision for the appointment of a Commissioner. Clause 4 states that those regulations may specify how the Commissioner's oversight and reporting role will be performed. And Clause 5 required that the first draft of these regulations was laid in draft in the Assembly within 2 years of the Act having received royal assent. It's also important, and Chair, you've already noted this, that another requirement of the Act is that all regulations brought forward under any provision of the Act are subject to the draft affirmative procedure, so that applies here. As I said in my earlier, I'm not going to go through each of the regulations in detail, but what I will do is just confirm that the regulations in front of you today give expression to what is allowed for and what is required by the Climate Change Act. That's to say that these regulations will establish the office of the Climate Commissioner. They'll provide a power for TEO to appoint a Climate Commissioner, and their core functions will be to oversee and report on the operations of the Climate Change Act. Members will recall that in late 2024, when the SL1 in these regulations was being considered by this committee, that there was some correspondence back and forth between the department and yourselves on a number of queries, and we issued a response to those queries on the 3rd of December. Members will also recall that in that correspondence, we noted that a consultation with the Climate Change Committee, the CCC, in summary, the CCC has concluded that consultation, that review of these regulations, and they have welcomed the steps being taken to establish a Climate Commissioner, and they have committed to working with the Commissioner once established and operational. To confirm, these regulations are not considered to be cross-cutting, and they therefore have not been referred to the Executive for consideration, and it's anticipated they will come into operation on the day after they are made. In drawing this to a close, I'm just going to say that this is an important first step in establishing the Climate Commissioner here. Once established, we will be the first region on these islands to have their own dedicated Climate Commissioner, and when considered alongside other climate advisory bodies which operate here already, so that's the CCC, the Office for Environmental Protection, and the Just Transition Commission, which DERA are establishing under powers given it by the Act, we will have a unique and genuinely world-leading climate advisory network and structure here. I will end there and take questions.
Okay, thank you very much, Colin. I appreciate that and appreciate all the work you've put into this. I just want to pick up on the point around the £1 million was one of the queries. So in the draft SR, it says the Commissioner may appoint such number of staff as the Commissioner may determine. It then goes on to say that this will require approval of the Executive Office and the Department of Finance. But what support will be given to this new Commissioner in terms of best use of public money, in terms of what the staffing structure will look like?
So we have benchmarked the staffing structure against other arm's length bodies that operate here and in other jurisdictions. We think there is a core staff complement of about 15 people, and that's where that £1 million will be. So some of that will be corporate functions, so making sure they have support on communications engagement, and some then on policy. So our plan is to have that in post. Now, what the Commissioner will have discretion over then is where some of those staff are placed, so which functions they choose to prioritise to make sure that they're discharging their part.
Okay, no, that's very useful, thank you. I suppose I think there was an expectation that this Climate Change Commissioner may move under the authority of ERA, for example, because that's where the scrutiny of that bill was, but it says it's STEM TO. Have you got an understanding yet or indication of where this office will be located physically?
It will be sponsored by TEO.
No, it will be sponsored, but in terms of actual physical presence?
We don't know yet. So we have been looking at options for accommodation and leasing when the office is established. But obviously until these regulations are passed, we don't have the power to do that and enter into any contracts.
Yes.
So we've been looking at the public sector estate and other options in terms of how they be placed.
Okay, and last one for me then, how long do you think, once these are passed by the Assembly, how long will it take then in terms of the recruitment process?
The recruitment process will be the same as most public appointments, and I know that it's something the committee has been considering in detail. So it's probably in that range of between 6 to 9 months once the competition is launched to get to the point of an actual appointment of a commissioner. Now, we have made a good head start in terms of developing things like the candidate information booklet, job specification, all the rest. So we won't be at a standing start at the point that the regulations, or if the regulations are approved. We have some of that banked, but you're probably in that 6 to 9 months before you have an appointment.
Okay, thanks very much. Go ahead, Deputy Chair. Thank you.
Thank you very much for that. That's all useful background information, and it's interesting just to see the whole process behind the setting up of a commission office, whether it's for meets and matches some of the other commissions which we have, for example, Commissioner for Older People and others. So presumably there's a reasonable template out there for the delivery of this type of body. It's a single commissioner. So is it a single commissioner? There's no deputy commissioner in respect of this particular post. And how many staff do you envisage to be required to support the commissioner? And will they effectively, the back office function, finance administration be delivered externally to the office, or is this going to be a complete package deal for the Commissioner?
Okay, so on the first question, will be a single commissioner. It will be a single commissioner, so it's not going to be a panel. In terms of the staff required, I've mentioned before, we think it's about 15 people required to support the commissioner. I would just like to confirm though that that's subject to a business case approval, and that still needs to go through. We think that's a reasonable sum. There's options where you could have fewer staff, options where you could have a larger number of staff, but the idea is that they would all be working directly for the Commission, so that will preserve the independence of that Commissioner.
Thank you.
Okay, thank you. Brian, please.
Thank you, Chair. You've answered some of my questions already. But thank you, Colin, for your attendance. I want to ask about the Climate Change Committee. I mean, we referred the regulations to them and they replied and said they had no substantial change. Will they have an ongoing role, and what is their role within government? I'm not clear how they operate across the 4 jurisdictions of the UK. You know.
Yeah, so the Climate Change Committee was established under the 2008 UK Climate Change Act, and they are a statutory body to provide advice on climate change, both mitigation and adaptation, both to Parliament and to all devolved administrations. So they will continue to operate, and in fact the Climate Change Act in some regards has strengthened their role around reporting and monitoring, particularly around requirements of the Act. So there are some specific reporting requirements on them. They will continue to operate alongside the Climate Commissioner here, and we have been in conversation with the Climate Change Committee for a long time about how we avoid duplication between those 2 roles and ensure that it's not about we're avoiding duplication, but we're also complementing roles where we go. But they will continue to operate alongside the Commissioner here.
And who is that committee answerable to? Does it operate under Westminster then?
Ultimately to Westminster, although they are co-sponsored by each of the devolved administrations. So DERA are the body that co-sponsors for here. And
I didn't see it on a scanning through the Act. Are they named in the Act? Then
they are named within the Act. There's a number of section clauses within the Act where advice of the CCC is specifically required. The requirement as it relates to climate change, the Climate Commissioner that we have, is at section 56. There's a requirement to consult with the CCC on any regulations being brought forward. So that's where we come in, but that applies to all regulations being brought forward by any body under this Act.
Right. And just last question on this particular matter. So how would you describe their role in relation to the Commissioner then? Would they be advisory then, or they have some sort of oversight role, but that's more over what the executive as a whole?
They will continue to have an oversight role, but I suppose how I would probably describe that relationship, the CCC are going to be primarily focused on the UK emissions position, so the aggregate of the 4 nations, the DAs and Parliament there. Now they do provide, and they have just on today, provide advice specific to this jurisdiction as well. So this morning they published a report on the 4th carbon budget. They'll continue to do that. What our Commissioner will do is provide a more forensic lens in terms of what is actually happening here, what departments are doing here, what policies, programmes, proposals we need to bring forward to give effect to our net zero ambitions.
And my last question, Chair, in terms of the Climate Commissioner, yes, they will sit under the authority of the TEO, the Executive Office, but are you satisfied that they will have sufficient clout in engaging with all departments and ultimately through the Executive Committee, I suppose, that they will have access to information? I mean, and their role is primarily to give advice and recommendations, So
they should do. I mean, they are enshrined in this Act as having a role. There's a couple of other requirements, so there's cross-references within the Act to where advice from the Climate Commission will specifically need to be sought by departments. So they'll have that, like I say, they can provide advice and recommendations to departments. There's no enforcement rule, so there's beyond that, the clout is not enforcement and it's not punitive in any sort of way. But they will have the power of any other commissioner here in terms of making public any of their advice, any of their recommendations, concerns, whatever else.
Okay, thank you, Chair.
Thank you. Timothy, please.
Thank you very much. Hello there, Colin. Couple of queries. So we know that net zero 2050, which is 25 years away, We read in the papers that this will be the first region of the UK to have their own climate commissioner. Why are we prioritising this above other regions?
I don't necessarily know that I would say that we're prioritising it. I mean, the thing I'd want to make very clear is this is a requirement of the Act that we have a climate commissioner here. It is required by law. In terms of why we would have a climate commissioner where others don't, the challenges are slightly different here than what they are in other jurisdictions. In that, for a start, we align with two legislative regimes around climate change reduction. We have our own, but we also still contribute on the UK climate change targets. And also the Act has made clear that we are part of a single biogeographic unit with the Irish government as well. So you could argue we're part of three. So we have quite a complex legislative framework there. The other thing, the nature of our economy is different than anywhere else across these islands. More dispersed population, fewer large economic centres, greater reliance on agriculture. So there are some particular challenges that we have from a public policy perspective that a climate commissioner could probably help give a bit more scrutiny to.
So time after time we hear at committee about when we're looking at historical and legacy and different things, it takes forever to see him coming out the other end, whereas this climate commissioner in my eyes seems to be prioritised. There's a £1 million budget for the person to create an empire. I think, like, to me this is absurd that this is something that's being prioritised. It blows my mind there's £1 million being set aside for this, to create an empire, for red tape, for bureaucracy, and to have this as something that seems to be steamrollered through. I certainly have massive concerns about. So that £1 million, can you give us a breakdown into how much of that is for staffing and how much of that is for infrastructure to help set up the office?
We can get you the breakdown after today in terms of what we think, although what I would say again, that £1 million you've described as having been set aside has not yet been set aside. It will be subject to business case approval and those monies being available. So just to be absolutely clear, not set aside and still subject to those approvals. But we will need to go through that process if and when these regulations are made. In terms of the Climate Commissioner being prioritised, again, I would go back to my first statement, and I've already said it somewhere else here today. This is a requirement in the law. So Section 50 of the Act, which has been in law now for almost 3 years, requires TU to establish a Climate Commission, and that's why it's being prioritised.
So looking at this, we have 25 years, we're creating an empire, and this empire will simply grow as time progresses. We look at the agri-industry and what this place has agreed to will absolutely devastate the backbone of our economy. What role will the Commissioner play in wielding the axe upon many farmers across Northern Ireland? Will they be providing information? Will they provide advice to the Area Minister, or what role will they have in the likes of that?
It will be when the Climate Commissioner is here. The Climate Commissioner won't have a role in holding any acts. They will provide advice and recommendations to departments here in terms of how to manage the transition to net zero economy. Part of that, what will be very important, is that they engage with a whole range of stakeholders, whether that be the farming community, whether that be businesses and community sector here. So they will have to engage right across the board.
So is the £1 million in the current budget that's out for consultation?
I'd have to go and check that. I'm not sure that it is, because even then, the £1 million budget is per annum. We would not be expecting much of that to be spent in the current year, given that there's going to be an appointments process that's required before then. So, with a fair wind, we're talking about an appointment of a Climate Commissioner within this year. That won't draw much of that £1 million, nor would the staffing by the time we work that through. So it's more likely to be from the next financial year on.
And final point, you had mentioned sponsored by TEO. Does that mean that the cost for this empire will come out of the TEO budget?
The cost of the Climate Commissioner, their operating budget, would come from TEO primarily, yes.
Yeah, just to put on record, I have serious concerns about the spend that's anticipated to be spent with the Climate Commissioner. I have massive concerns about an empire set up and no good will come of this. Northern Ireland is quite small on the global scale. We have a duty to make sure the planet is passed on to the next generation, so, you know, in better shape than we inherited. But I think going down this route of having somebody wielding the axe going through a lot of our industries isn't the right way. This won't support business. This will not support our agri industry, and certainly I have concerns about what's proposed regarding the budget that will be associated with this.
Okay, thank you, Timothy. Sinead, please.
Okay, thank you, Colin, for that update. I would say it's taken a long time to get here, actually, Timothy. It hasn't been a quick process at all. This is 3 years in the making. It's already in law that we appoint a climate commissioner. So I'm happy to see the bones of it working through, and I would think that the commissioner is going to be there to support our businesses as they try to achieve the targets that we've set as well. So to support businesses and the sectors, particularly those in agri-food, so that they can be supported through this process. And that was the reason, because of the complexity of our economy even here in Northern Ireland, is why that the climate change, or the climate commissioner, was put into the legislation. So I welcome that. Obviously, you know, there was no legal requirement to carry out a public consultation, but will any engagement take place on the commissioner with relevant groups and representatives other than the Climate Change Committee? Is that factored into it in any shape, form or fashion?
So we have. So as you say, this has been, you know, almost 3 years since the Climate Change Act was passed and given royal assent. In that time, we have been engaging with a wide range of stakeholders, business, members of the ENGO sector, with political parties at the All-Party Group on Climate Action, and also our universities. We've engaged there, and some, though not all, to be fair, of the councils. We have absolutely no qualms with continuing that engagement and expanding it, particularly as we get into the operationalisation of the Climate Commissioner.
And I know that, you know, I have been approached in my office asking, you know, what's keeping you? Why is there no commissioner at this stage? So I think that there's a lot of bodies out there, including our universities, that are looking for that type of engagement. So you said that we're the first region in the UK to actually establish a commissioner, but is there any other best practices that you have looked outside of the UK that are that have a commissioner, or of a person or an office of that standing, that you have gleaned any best practice from?
There's quite a lot of climate advice bodies that operate globally. One of the ones that actually, to be fair, is held up as a model of best practice is actually the CCC that operates on a UK basis. They were, I think I'm right in saying, the first kind of formal climate advisory body that was set up anywhere globally. And there's now a network of over 20 different countries have their own. They all take slightly different approaches, and to be fair, what they do, or what they have tended to do, is match the approach they take to either the economy or the challenges they have. So the ones that stand out would be New Zealand, for example, takes a very precise role in terms of scrutinising what are their climate change goals and targets, and they monitor those. The Swedish government has a slightly broader role, so they assess how all government policy aligns to climate change goals, so they take a broader perspective. So they're on both ends of the spectrum. There's a whole other swathe of them. Some others prefer to go with the Just Transition Commission approach, and like I say, so what that is make sure that we make a fair and equitable transition to net zero, and that's something that the Act allows for us to establish through DERA. So there's lots of different models that are out there, and we've looked at all of those to try and see, well, what is best fit here. Now, what I would say is our Climate Change Act is quite prescriptive in terms of saying we will report and oversee, or our Commission will report and oversee on the Climate Change Act. So that kind of provides a framework for what we'll do, but we've looked at those other models.
Okay. Thank you.
Thank you, Sinead. Harry, please.
Thank you very much, Chair. You mentioned the 5 clauses. Colin, could you maybe elaborate a wee bit more on Clause 4?
So Clause 4 says that the regulations may specify how the reporting and oversight roles of the Commission would be undertaken. We have in the regulations draft this to say that it's through advice, recommendations, by publishing reports. Knowing that the Act doesn't provide any enforcement powers, so what we've done is we've taken advice on this, taken strict definition or a strict interpretation of what overseeing and reporting means, and that's how we've come to that conclusion there.
No enforcement powers, it's
No
like
enforcement
advice.
powers, no.
So it's similar then to Great Britain, where there was no comparable legislation, the 2008 Act, where it's just a body which provides advice also.
That's
Similar.
the CCC
Yeah,
provides
yeah,
advice.
Yeah,
Yeah.
yeah, okay, thank you. Thank you.
Okay, thank you. Carol, please.
I just wanted to try and ascertain, see the figure, would that be in keeping with the establishment of other commissioners in their offices? Because we couldn't quite work out what it was last week.
The £1 million is broadly similar. So I think the operating budget in the last financial year for the Commissioner for Older People, I think ended up being just over £1 million. Children and Young People's Commissioner was in and around that. I think it was slightly lower. Equality Commission is higher, but they have a broader range of powers. So in terms of bodies that have that kind of advice type function, it's in and around that region.
And this is really, so are you saying, I mean, this Commissioner's office has been established from the legislation that was brought forward, including the amended legislation. So this Commissioner's office has to respect the legislation that was brought forward by the Assembly here?
Absolutely, and that's the position. The law that's in place here that was passed by the Assembly requires us to establish a commission, and that is what they will operate under.
Okay, listen, that's all I need to know. Thank you.
Okay, thank you, Carol. Not get Claire. You haven't indicated. No, you're okay. Okay. Well, listen. I think that's everything. Oh, sorry. Go ahead.
Yeah, could we get a breakdown of the structure? So out of that 15 FTE, how much of the £1 million, proposed £1 million will be for staffing costs? How much of it will be the infrastructure essentially for the office? To give us an idea of average salary. So much is the Commissioner going to be on? How much is the average worker?
Provide some of that now. So the Commissioner will be paid the same as all Commissioners are paid here. So it would be on the grade 5 scale across the civil service. I don't know the actual figure off the top of my head. I'm just saying that's the pay band for all Commissioners here is in that grade 5 range. But we can provide that breakdown. The caveat I will provide again is this is subject to business case approval. So that is an estimate based on what we think is reasonable to actually have an effective and efficient Commissioner's office. We will provide those figures in detail to you.
Okay. Go ahead, please.
I'll just say,
Then Brian.
to be fair, this is nothing unusual or different from any of the other commissioner appointments that we have in Northern Ireland, and to suggest otherwise would be unreasonable. Thank you.
Ryan.
I just want to check in terms of what we have in our meeting pack. We have draft regulations, draft statutory rules for Northern Ireland 2024. There's not a specific date on it. When you're talking about the 5 clauses,
The 5 clauses are from the Climate Change Act.
right? I was saying they didn't tally with these here.
No, and they don't. So I suppose the reason I was providing the summary of those 5 clauses is that provides some of the context for how these regulations then have been drafted. So those 5 clauses, just for your convenience, they're in the 2022 Climate Change Act, that's section 50.
Okay. And again, I was looking for the mention of the Climate Change Committees. I don't see it in the regulations that we have.
They're not
in that.
referenced in these regulations. They
Is that in the
kind of
2022?
are tangentially. So I think it's at Regulation 6, which gives the Commissioner power to cooperate with other bodies across the UK and other jurisdictions. So they're covered within that in the regulations. But again, they're named specifically within the Climate Change Act.
Right. They're mentioned in the explanatory note
Yeah.
once, but although that's just in terms of consultation over setting up the position. Okay, it's just to know that we have that I have the right paperwork. That
Yes,
we're
there
considering.
probably is, to be fair, there probably is 2 documents to give you a complete reading of it. There's the Climate Change Act from 2022 that was passed by this Assembly. Section 50 relates to the Climate Commissioner, and then there's these draft regulations.
Okay, thank you.
Okay. Okay. Thank you so much, Colin. I appreciate that.
Thank you.
So, members, we've that one request from you, Timothy. Was there anything else anybody else wants to follow up on, or?
We still await the Examiner Statutory Rules opinion on the legislation at this stage, so we can't take it any further today.
Okay.
And there was a query of that 1 million is contained within the budget currently out for consultation.
I think we got an answer to that, Chair, did we not?
Yeah, I think we got an answer, but as I said in my remarks, that we will get a departmental briefing next week on the budget, so you can maybe raise that then as well.
Yeah.
Okay, if we're content to move on then, so just to seek your agreement to formally consider whether we are content with the statutory rule as drafted following the examiner's report. As I said earlier, we expect that on Friday the 21st of March, and then seek your agreement that this item is then added to next week's agenda for formal consideration at our meeting on the 26th of March.
Agreed.
Okay, thank you, members.
Maybe noted as sceptical.
So noted. Okay, we'll move on to item 7 of our agenda, historical institutional abuse. So we've got an oral briefing from the Assembly Research and Information Service. So thank you so much, Thomas, for coming back. So members, I'd refer you to page 46 of your pack for the clerk's brief. We're going to welcome to the meeting Thomas Luff, who's a research officer here, and thank you for all your papers in advance and all your work.
In the right, I'll just there we go.
I think members were emailed out a PowerPoint presentation about an hour or so ago. I'm just checking, Claire.
It went in the pack.
Oh, went in the
It
pack.
was in Friday's meeting pack.
Okay, it was in Friday's meeting pack. Okay. Okay, please go ahead, Thomas. Thank you.
Thanks, Chair. Thanks for having me back. Last year, I think it was, the end of last year, I came to speak to you about how historical institutional abuse redress processes had been responded to by the Irish government, and the committee was interested to see how that had similarly been addressed in Great Britain. So this paper covers a bit of that. Obviously, there's quite a lot of bits and pieces, so it's fairly high level overview, but you'll note in the paper and in this presentation, one of the areas I've concentrated on is the financial redress scheme that's in place in Scotland. I know the committee had a particular interest in how the kind of financial redress works and is funded and things, so I'll go over that as part of this. So just to briefly let you know what I'll cover just now and what the paper covers. So I'll begin with Scotland. That's not just because I'm from there and slightly biased, but they are a little bit further on when it comes to the financial redress, as we'll see. So I think that's probably a useful place to look at. So I'll start with a brief overview of some previous reviews and inquiries that have taken place in Scotland. Then we'll turn to the Scotland's redress scheme. I'll touch on the Scottish Child Abuse Inquiry, and then we'll move to England and Wales and the independent inquiry into child sexual abuse there. And then finally, I'll just quickly touch on the Criminal Injuries Compensation Scheme in Great Britain as well, which is relevant here. So there's a table in the paper. It's pages 8 and 9 of the paper. I don't know where it is in your packs, I'm afraid, but that gives an overview of some of the kind of more relevant inquiries and reviews that led to some changes. So I've just mentioned a couple here, just for time. Firstly, there's the independent inquiry into abuse at Carrowlaw Residential School and Secure Unit in 2009. This was jointly commissioned by both the Scottish Government and Glasgow City Council 2 years previous, following hundreds of allegations of emotional, physical and sexual abuse over the years during which the facility was open. The inquiry's purpose was to secure comprehensive insight into the circumstances that led to the abuse and to examine the council's stewardship of the school and the subsequent council investigation of what occurred and what arrangements were in place following the closure of the school. So the report made a number of recommendations, which I won't go over into detail. These were mostly addressed to residential childcare providers, and they were kind of Scotland-wide. They weren't just specific to that school. They could be taken wider. They didn't really focus on legislation, noting that legislation and policies had actually moved on quite a lot since the school had closed, but they were kind of really looking at the staffing and training of staff and leadership and kind of listening to children and taking seriously any issues that they raised. So it was more about the kind of the culture of the staffing in the school. 2007 was the Shaw Review, otherwise known as, apologies for the long name here, but the Historical Abuse Systemic Review, Residential Schools and Children's Homes in Scotland 1950 to 1995. So you can tell by the title it's a more a wider review of children's homes in Scotland, and that was an outcome of a debate in the Scottish Parliament in 2004, seeking an inquiry into past institutional child abuse. It was a systemic review looking at regulatory framework, governing residential schools and children's homes, and made a number of recommendations around strengthening welfare and safety of children in the care of the state, and ensuring proper preservation of and access to public records. And that led to, in part, the Public Records Scotland Act 2011. The next slide, which I apologise, is not, you won't see. This is the only one that I've included extra because I realised I was too organised and sent that too early and didn't have this one in. But it's just to give you a quick idea. I think we mentioned last time that financial redress obviously isn't the only type of redress, and there are a number of non-financial redress measures. So this is just a brief outline of those. So there was an apology on behalf of the Scottish people made by the First Minister in December 2004, and then an apology on behalf of the Scottish Government made by the then Deputy First Minister in 2018. The establishment of the Scottish Child Abuse Inquiry in 2015, which we'll come on to later. The establishment of Future Pathways, which provides personal outcome-focused support to survivors of abuse and care in 2016. The passing of the Apology Scotland Act, intended to encourage a change in social and cultural attitudes towards apologising, and the passing of the Limitation Childhood Abuse Scotland Act, which removed the 3-year time limit on personal injury claims for damages in respect of childhood abuse. We can cover any more of those that I don't get to in the paper in questions if there's anything specific, if I can give the answer. So on to the actual financial redress scheme itself. This opened in December 2021 properly, following the passing of the relevant legislation. The legislation also set up a new body called Redress Scotland. They are the body that makes the decisions. They're independent of the government. So the scheme as a whole is administered by Scottish Government, but the decisions are made by Redress Scotland. So as we'll see in a second, the process goes between the two, those two bodies, depending on the application status. It covers abuse that happened when a survivor was in a care setting in Scotland, and they were below the age of 18 before the 1st of December 2004. There was also an advance payment scheme for those who'd suffered abuse who either had a terminal illness or were aged over 68. That scheme opened in April 2019, which provided an ex gratia payment of £10,000 alongside a reiteration of the Deputy First Minister's apology. That continued to operate until the opening of the full statutory scheme in 2021. This next slide is also in the paper on page 15, which might be a bit easier to read. So I won't go through it, but it's really just gives you an idea of how the application process works. So it begins with the form, and you're given a caseworker, a Scottish Government caseworker, who stays with that survivor through the whole process. And then the decision goes to Redress. The application goes to Redress Scotland, whose panel make a decision. Worth noting that I don't think on there is that there are 6 months to accept an offer, but if you want to review it, you only have 8 weeks with which to review the offer. So there's a slightly smaller time window for that. 2 types of redress are available for survivors: a fixed rate payment of £10,000 or an individually assessed payment of £100,000. So just to briefly kind of go through what those two involve. For a fixed rate payment, survivors must show they were living in a care setting when they were abused. They don't need to give documents as any evidence of this abuse. They just need to provide documentation that they were in a care setting at that time. They will need to provide a statement as well. For both of these types of payment, a survivor will provide a statement, but they could also use, for example, a previous police statement that they had maybe given to avoid repeating it. For an individually assessed payment, there will need to be supporting documents as evidence of the abuse is required. The panel will take into account things such as the nature, severity, frequency, duration of the abuse, and other relevant matters as well. And there are 5 further levels of payment on top of the £10,000. So total redress can be 20, 40, 60, 80 or £100,000. If the survivor accepts a payment offer, any UK benefits they're entitled to aren't impacted or reduced or stopped. And you can see some numbers there from the latest annual report. So as of March last year, almost 2,000 initial applications passed for consideration and over £66 million made. There was actually a slightly updated stat to June of last year, which has around £76 million in payments made. We're saying as well, actually, they are, once a survivor receives their determination letter alongside the offer of a payment, if that's the decision, they are able to request an individual written or face-to-face apology from any or all of the organisations named on their application form, and they can ask for an individual apology from the Scottish Government themselves as well. There's no obligation for organisations to provide that apology, but it's hoped that the government hope in the spirit of the scheme they will consider those requests. I do have some numbers as well if you're interested later on about how many of those have taken place. Onto the funding of the scheme. So survivors who accept a payment must sign a waiver. That's similar, I think, when we discussed one of the schemes in the Republic of Ireland. So a survivor must sign a waiver which says they won't take any civil action against that organisation. The scheme is funded by the Scottish Government and responsible organisations who commit to what's called a fair and meaningful contribution. There's a list of the organisations on the website. Scottish ministers are required to keep a list updated of organisations who contribute. At the moment, there's about 20 organisations, and their contributions total over £122 million.
Sorry, how many did you say?
20 organisations.
Okay.
Yeah. There's a list of them in the paper as well. But yeah, the most up-to-date list is on there. Worth saying that the waiver is only you have to sign the waiver, but if the organisation that you have named on your application is not on the list of contributors, then you can still take civil action, even if they're added at a later date. It's only on the date that you sign the waiver that if they're on the list, and they can also be retrospectively removed from that list as well. So as well as the redress scheme, there's the Scottish Child Abuse Inquiry. This was set up in October 2015. It's ongoing and hasn't provided a final report yet. There are 117 investigations have been announced and kind of 12 broad themes, again outlined in the paper. And just to note, the current cost is just almost £92 million so far. That's on the inquiry, that's not on redress, that's a completely separate area, so this is just in the inquiry itself. Moving away from Scotland into England and Wales, I'm sure you'll probably be aware of the independent inquiry into child sexual abuse there, again established in 2015, and the final report was in 2022. During that period there were also 19 investigation reports published. These covered a number of areas, 2 areas where there have been some redress schemes set up off the back of those investigations. One was in the case of child migrants. These were former British child migrants separated from their families and sent overseas. The UK government agreed to financial redress, and that scheme opened in 2019. Applicants who were eligible received a payment of £20,000. And the other was to do with Lambeth Children's Homes in London as well, and over £71.5 million was paid out through redress on that specific scheme.
Can you just ask, in respect of the migrant schemes,
Mm-hmm.
was that a UK-wide scheme or was that specifically England and Wales? And if it was UK-wide, were there any children from Northern Ireland included in that?
I'm not actually sure on that.
Sorry. Yes.
Maybe you know the answer.
Yeah, I do. But so they were excluded because this UK-wide one was, so any of them that went to Australia, etc. Because they were sort of coming through at the same time. So they could have come from Northern Ireland, but the UK government paid the compensation.
Okay. Thank you.
Thank you. We can swap chairs.
No.
No, thank you. Appreciate that. And then just to say, there's 20 concluding recommendations in the final report, so they're separate to the investigation reports. One of those talks about establishing a redress scheme as per in Scotland. Nothing so far has been established in terms of a redress scheme. The Labour government, in a debate in the House relatively recently, did note that redress would have to be part of this process, but there's been nothing more firm than that in terms of what a scheme might look like. And then finally, just to finish, the criminal injuries compensation scheme. So this is a government-funded scheme open in Great Britain. There is a similar scheme that operates in Northern Ireland, but the paper doesn't cover that just due to the scope, so I've just concentrated on this scheme. This is not a specific scheme for survivors of abuse. It's open to people who are victims of violent crime under certain circumstances, but survivors of abuse may be able to may be eligible for an award through that. That's set by the Secretary of State for Justice in Westminster and approved by Parliament there. There were some recommended changes from the Child Sexual Abuse Inquiry around the scheme. Those haven't yet been implemented. The scheme has kind of been discussed for a review for a number of years. It was last updated in 2012, so it's quite an old scheme now. But no changes have yet been made on that. So yes, that's hopefully gives you a bit of an overview. I know there's quite a lot in there, but I'm happy to try and answer any questions that you might have.
Okay, thank you. Thank you very much, Thomas. I have a few questions. I suppose what jumped out at me from the papers was the Apology Act 2016, and you said there it was intended to encourage a change in social and cultural attitudes towards apologising. And you know, I suppose when you read through the paper and look at it in the context of also the Republic of Ireland, there's just been so much child abuse. It's horrendous. Mm-hmm. So I suppose in some ways I was more looking for the word change in social and cultural attitudes towards children. But I wonder, can you speak to the issue of that Apologies Act and how it has been received? Because obviously not everybody's about financial redress. Some people just want that apology. So I'm just wondering, did you come across anything around how that's worked in practice?
Yeah, the Act itself was brought forward by a private member, Margaret Mitchell, who was a Scottish Conservative MSP. It had a huge amount of cross-party support, and is kind of held up in some ways as a model of taking legislation through in terms of the amount of consultation that was done and party support in that respect. It makes clear that in civil cases, an apology is not an admission of liability. So it's really encouraging organisations, especially in the area of historical abuse, to apologise, and that's important without having the fear that there's a lot. People will think, oh well, if we apologise, we're admitting we did something wrong. So this act was supposed to help with that. I think it's been well received within like the legal profession and such as well, and that's kind of what the Scottish government took into the redress scheme around the. So when an organisation is deemed to have made a fair and meaningful contribution, and they're added to the list as part of that, and it's published on the website, they also have to provide an apology, a written apology that's public for everybody to see, and then this idea that the individuals can request a specific face-to-face apology. So it's building in that, I think, that culture of wanting to acknowledge what happened, without, so it's just providing that and making people want to come forward. So the government cannot mandate an organisation to make a contribution. It's all done on trying to change that culture and trying to encourage them to come forward. And so far, 20 organisations have done that. Now, they concentrated initially on a lot of the organisations that they knew were responsible, but the idea is that other organisations who are maybe smaller or haven't been identified yet by the Scottish Child Abuse Inquiry will come forward and contribute to the scheme as well.
No, thank you very much. See the Public Records Scotland Act 2011, what we are hearing quite a lot at this committee, especially from historical abuse cases, it's the lack of access to public records, and sometimes they'll receive them to be redacted or bits are lost stuff. So to what degree have they been able to get around a lot of the data protection barriers that exist here, for example?
I'm not massively au fait with that
Okay.
act
That's
in
okay.
particular. Maybe though just worth noting for the redress process, when documentation is required by the panel to make a decision, specifically on those individually assessed payments, there is a provision in the Act that allows Scottish ministers to compel that evidence from an institution, if all the other means have been exhausted by the survivor and other organisations. And Redress Scotland, that body that makes the decisions, can direct ministers to compel an organisation if, for example, I didn't look to see if there was any evidence that happened thus
No,
far.
it's fine.
But that is available to ministers.
Okay, thank you. Very last one for me. So the caseworkers in the redress scheme, so under HIA, that was sometimes a legal firm provided it. Is the caseworker that you've identified, is that a civil servant or is that legal representation or what?
Yeah. So the caseworkers work for the Scottish Government, and they're part of a body within the Scottish Government that basically takes. So the Scottish Government administers the scheme, and Redress Scotland make the decision. So the caseworker is with the survivor, the applicant, through the whole process. We'll talk them through how it works from the start. When they want to make an application, they will be the ones that send the application to Redress Scotland. They're the ones who Redress Scotland will basically speak to the survivor through, unless the survivor has approached Redress Scotland directly themselves, usually with a complaint or something like that. But otherwise, everything goes through that caseworker. So the survivor has a person that they can. But yes, it's a civil servant who do
Thank
that.
you. Deputy Chair, please.
Okay, just to follow through on the questions around the apologies side of things, do we know, is there any indication of how many people have accepted an apology as a means of redress? I think one of the areas of concern here has been that apologies given so far are not perceived to be, I think to say that they're not genuine isn't fair, but that they are perceived to be written, stilted, formal, and not in the sense of heartfelt in that respect. Has the apologies legislation in Scotland addressed any of those elements of it?
So it was interesting looking at some of the feedback that Redress Scotland had when the scheme was first open, and most of it was actually around the process rather than, interestingly, I didn't really see a huge amount that touched on the apologies that are requested, that are kind of posted up on the website there and they're had to make. When you look at actually how many people requested a face-to-face apology from the institution, so this was in the first 30 months of the scheme up to June last year, almost 1,600 decisions were made and overall 110 apologies were requested. So it's not a huge number of people that are looking for an apology on an additional kind of face-to-face. Now, I'm sure there's a number of reasons why you wouldn't want a face-to-face apology necessarily, but and of those, 63% were received. So not everybody received an apology who requested it. Now, they may receive one subsequent to when this data was provided, but they hadn't yet. But it is kind of that culture of saying that you can contribute to this scheme, but you're not just contributing the scheme to kind of make yourself feel better. You should also provide this apology, and it's made public, and that's done, and that seems to have been relatively successful, at least so far.
And in terms then of compensation, those organisations that have contributed to the compensation, what's the sort of broad assessment of that? Has it been getting blood out of a stone, or has it been generous? What's the sort of range of reaction to that?
Well, so a body can't just say I'm going to give say £10,000 now. Everyone can sign a waiver and sort of I'm free from. So the fair and meaningful part is quite an interesting one. It's obviously very difficult to define, if not impossible. But the Scottish Government does have some wording on what fair and meaningful is, so it says, it's one where an organisation that's relevant to an application for redress pays the relevant share of any individually assessed payment above and beyond the Scottish Government's contribution, first of all. Now, that contribution for an individually assessed payment will either be £10,000, this is the government contribution, either £10,000 or a third of the total contribution, of the total award. The organisation is expected to pay the rest of that, so the 2/3. There's modelling exercise that they've done for each one as they become part of the scheme to roughly estimate what each organisation may be liable for. Some of them have agreed caps with the Scottish Government, but not all of them. So some of it is open-ended, and they continue to pay into the scheme as it goes on, but haven't paid sort of a one lump sum, as it were. And then the meaningfulness is about that sincerity and the commitment. So as well as the apology, anyone on that organisational list has to provide a yearly report about what actions they've been taking in relation to redress. Government can also mandate other organisations who aren't on the list to provide a yearly report on redress, and they've done so 4 times, to 4 organisations, sorry. And organisations can voluntarily provide a report even if they're not contributing. So,
and in terms of compensation, does the Scottish Government have powers to investigate the ability of organisations to pay, and do they have any say in the amount of property that's held, or assets, or trust funds, or gifts that have been given over the years that may be entailed for particular things, but they're basically saying, no, you're going to have to open those bank accounts and pay the money?
It wasn't something I was able to find exactly how that kind of modelling was worked out for some third sector organisations. So there are obviously some Bernardos and Save the Children in that list of contributors. Now, I don't know if they are the ones that have a cap, but for example, there will be affordability caps within that. But and that would be done on what an organisation may actually physically be able to pay. But I'm not sure exactly the detail of how that's worked out, or whether they're able to. I mean, I imagine there must be some sort of opening of the books if you're working all of that out, but it's not clear from what I could find of exactly how that takes place or what they're able to do.
Okay, thank you. Brian, please.
Thank you, Chair. Thank you, Thomas, again for attending. It's a very helpful paper you've put together, and it will be of no comfort to anyone but to see how similar issues have occurred elsewhere, and again the scale, which is appalling. I mean, reading your summary document for Scotland, going back to 1992 review, which produced conclusions, 1997 recommendations, 1999 recommendations, 2002 recommendations and an apology, 2007 recommendations, 2009 recommendations. So it wasn't until 2021, if I understand correctly, that the redress scheme opened. So there was 30 years of recommendations and maybe an increasing scale of apologies before there was actually any redress. It was just seen as, we need to improve the system. It seems to be a lack of wanting to address the harm that had been done to individuals. That's how it seems to me. I don't know if you have any comment on in terms of looking back over that history.
Yeah.
Am I correct in thinking the redress didn't start till 2021?
Yeah.
And all these reports which were establishing that there had been what were those early reports? Were they highlighting that abuse had occurred, or?
So some of them were looking at very specific, so a single person who had been convicted of abuse in a home or a number of homes. So some of them were looking into how that occurred and what was what was done around it in that specific place, and then some of the others, maybe kind of into the 2000s, where you start to get ones which are a little bit wider and actually looking at Scotland wide, or at least their recommendations are kind of taken on Scotland wide. But yeah, you have the first apology from the then First Minister in 2004, but interestingly, that's on behalf of the Scottish people that he was apologising. I think that was Jack McConnell at the time, he was the First Minister. And then the later apology on behalf of the government isn't until 2014, and that's just before the inquiry is set up. So yeah, like you say, this has been going on a long time, and it's taken a while to get both the financial redress and those kind of those other areas of redress set up as well.
Yeah. I think Scotland, in terms of the redress scheme, Scotland is ahead of us in that theirs is established, it's been running. When I look at the figures, let me see, 66 at the end of March 2024, 66 million paid out.
Now 76, did you say?
Yeah, it's now 76, just 76 and a half as of June. So it will be even. Yeah, I mean, I suppose we'll be getting the next annual report relatively soon.
Right, and the amount paid in by institutions is higher, 122 million. Is that right? Now, we're in the other opposite position, and that the amount paid in is less, maybe half what has been paid out. So, and I know there's a cost of the inquiry as well, but have you any feel for how many more payments are in the system or are likely to be required? Maybe?
No, I think that my understanding, though I wouldn't be 100%, but my understanding is that 122 has essentially been, that's what's been modelled on those organisations. That's what they will contribute. Now that's either the caps that are in place or other organisations who they've kind of established will pay X. They kind of try to work out how many individuals they think have been in the care of that organisation at the time and model it through that. It's hard to know though, because it has taken a lot longer to go through these applications than was expected as well. So again, the cost is kind of a bit unknown there. But yeah, it will be interesting to see the kind of latest numbers and how close to that 122 they get. The government is still looking for more organisations to.
Well, that was my next question.
Yeah.
Do you know how many have yet to make contributions? You don't have that?
I'm not sure, no. There wasn't anything around that. But they are, I think another one was added at certainly the second half of last year, I think. So they are continuing to add to that list. They can also remove organisations from that list. That hasn't happened yet, but they could if organisation defaults on their payments, for example.
Mm-hmm. And if an institution contributes to the scheme, they're effectively, I don't want to use the word insurance policy, but it almost is like that, but the people who accept a payment are signing away for that they won't sue the organisation individually, which is a terrible decision that people are put in.
I think, just to say, Brian, I think the difference, or one of the differences that's maybe noticeable, if you look at the list of organisations on the contributor list, is the variety of the types of organisation that they are, which may differ from the institutions you're talking about here. So you're looking at the local authorities, for example, are all on that list. They have all contributed or will all contribute. Mm-hmm. Now, how they work that out with local authorities is a bit different to the others, just because obviously it's of the public funding. But you have a kind of a variety of individual schools who were, some religious institutions, but maybe that would be different to how the list might look here, if you know what I mean. So whether that's played a part in how they've been able to come forward, I'm not sure. But it is. But if you look at that list, it may be kind of different from the kind of list you would get here, and certainly different from the list in the Republic of Ireland as well. So
that there's less of the religious institutions.
Yes,
right.
It's not as. I mean, there are still quite a few on there, but you have a lot of other bodies, other kind of third sector charities that are not affiliated with any religious body, for example.
And last question, Chair. In terms of England and Wales, it's fair to say they're further behind then. And again, have you any sense of the characteristic of abuse which occurred? I mean, obviously, it's a much bigger jurisdiction. England and Wales, much bigger, the two countries. Is the scale not thought to be on the same level?
I mean, when you look at for example, the Lambeth scheme, which was only for the London Borough of Lambeth, they paid out over 70 million just there.
Right.
That probably gives you an idea of the sense of scale and
Right. It's
that you're talking.
It's
It's vast.
Right.
And I think the reason Scotland is far ahead, and I don't know why they made that decision, but they decided to put that redress scheme in place while the child abuse inquiry was ongoing, whereas the England Wales inquiry, the redress scheme was one of the recommendations out of the end of that, as it were, and that inquiry has now finished. So this kind of Scottish ones are running in parallel, whereas England and Wales they've said they will potentially bring in a redress scheme now that the inquiry has finished, but that hasn't happened as yet, and there's no concrete.
Okay, I mean, my final comment is that it just seems like everywhere this has occurred, society has been slow to come to terms with it and face up to what occurred, and the need to provide redress, to those who suffered. Okay.
Thank you, Brian. Sinead, please.
Okay, thank you so much for this paper again, Thomas. Did you come across any evidence how they established the 10,000 payment? How was that established, and then how did they make the differential between the other type of payment, which can go from 20 to 40 right up to 100? What was the decision making process in order to get to those payments?
So I'm not 100% sure in all the detail of that, but they were looking at other schemes that were already in place around the world and the affordability, understanding that if an organisation is not on the lists, then the Scottish Government will still pay the full amount that person is awarded. So they kind of had to build in those those affordability criteria as well. So even if an institution isn't on the list, it wouldn't affect a survivor's payment. The payment is still provided by the Scottish Government. So they had to build that in. But it was looking at other redress schemes of the same or similar type, or just other payment schemes. And the £10,000 was really sort of decided. That was a kind of one that they felt they could give fairly quickly as well, with that lower sort of threshold of having to, someone doesn't have to provide loads of details about their abuse, they just have to show that they were in that institution. But there is a little bit, I think, in the consultation around how they came up with that number, so if it's something you're interested in, I can certainly dig some of that out for you.
And in relation to the fair and meaningful contributions as well, so if obviously it's a numbers game in terms of those that are presenting themselves, so is that evaluation of who's coming forward and where they were actually placed in, or the home or the institution that they were in, that's all factored in there accordingly as well. So it's not one fit, and I think from the data that we've been given back about the churches and institutions and that, I just can't see the methodology. I can't see how they're making the requests for contributions from the institutions, not knowing exactly the number of people that are going to come forward that were abused in those institutions. And I'm just wondering, is the formula, I hate talking about, it's terrible because we're talking about victims of abuse, but yet I'm trying to make sure that the contributions that are coming forward from those places that abuse them is fair and meaningful. And because, in the absence of that, those that are abused are still going to be really hurt as well. So just bear with me when I'm kind of thinking this through. So Redress Scotland, what is how are they constituted as an organisation, from the actual government itself in order to make those payments? You know, so I'm just wondering if we have barriers here, how can we overcome them? And is the structures of Redress Scotland a way of getting payments done quickly without?
So Redress Scotland have nothing to do with the payment at all. Their only role is to make decisions on the applications. So there's a panel of 2 or 3 people who will look at the applications and make a decision. Usually they make a decision first up. Sometimes they will need additional information, but that's then passed back to the Scottish Government. They're the ones who they will pay what Redress Scotland have advised they will pay. It's not like it goes back to Scottish Government and they go, oh, maybe we could. That number is, that decision is made. In terms of kind of how that's worked out, it's quite, I imagine, quite complicated. All I've really kind of got around that is there was a modelling exercise around potential number of applicants relevant to each organisation when they consider making a contribution. And there can be a review mechanism within that agreement so that, for example, if actually the number of people who come forward during the lifetime of the scheme is much less than modelled, then an institution's payments will come down and vice versa.
Right.
And whereas there's insufficient data to apply any modelling, they centre on the payment of the accumulated cost of all determined applications where that organisation is named. So it's kind of done afterwards, if you know what I mean. So they'll see an application X or institution is named this 1,000 times, right? But then we'll take a payment of kind of relevant to that. Does that make any sense? How they've actually worked out these numbers is not entirely clear.
Right.
But they will try to work out how many people will be individuals would be in each institution and the type of abuse that they may have suffered, and therefore what the payment would be.
No, that's excellent. But I suppose from our perspective, I'm sure I'm not alone in the committee. I'm not entirely clear what model or formula is being brought to the church organisations and bodies.
Clark had just suggested that we possibly could write to the Scottish Government to ask for that.
Yeah, I just think it would give us a bit of clarity here when we're in that pursuit. Now, the other question, the inquiry itself has cost the Scottish Government 92 million, almost.
Oh, it will be over 92 million by now. Yeah.
And how did they fund that? Where did that money come from the Scottish Government? Like, you know, where?
I'm not sure. I think it just comes from their kind of their central pot. I mean, it has been going since 2015, so you know that's 10 years worth of inquiry already. I couldn't see any indication of when they think it will stop, so it could go on for a bit further now. So
it's just something to
consider. That's worth noting as well, just in terms of how long the redress scheme is open for. It's open for 5 years from when it opened, which was December 2021, or 2 years after the Scottish inquiry closes, whichever is later. So it will either finish it will finish 2 years after the inquiry finishes now, because that will be the later of those 2 dates. So it'll be 2 years from whenever that stops.
Thank you very much. There's great information here. Thomas, no doubt, we'll probably maybe come back to you and ask you something.
Thank you, Sinead. Carol, please.
Thomas, thanks very much for your paper. It's very, very detailed. And like everyone else has said, it's just disturbing the amount of children and young people's lives that have been destroyed through abuse, be it physical, sexual, and all that and more. The thing that jumped out at me was that the Scottish Government's inquiry's gone on 10 years, and it was just your last point there. Potentially, unless it's ended, we need to, and I suppose, write to the Scottish Government in terms of how they calculated the interim payment is interesting. But have you any idea the number of witnesses or statements that have been given in up until now? I know it's probably approaching, well, it was 76 million last year. It's probably 80 plus at this stage. But many people have put in for the interim payments, or many statements that have been given.
So for the redress scheme, so the most up-to-date number, which is slightly different from the one on the slide because there are some more up-to-date ones, was 1,600 decisions were made. So there will be slightly more than that applications made, but 1,600 decisions. And just out of interest, so 97% of them are the offers were accepted as well. So most people are accepting those offers. Some people are reviewing them, but a very small number. So they're generally accepted, those offers. And then in terms of the evidence, usually Redress Scotland will take written evidence. So a survivor will provide basically a statement of what happened to them and any other evidence they may have. The panel can ask them to give oral evidence. That's usually only if they have no other way of getting what they need to make a decision, and the survivor does not have to provide that oral evidence. But obviously, if they don't, it may impact the decision that's made. But that's quite a rare occurrence. That doesn't happen regularly.
But would I be right in saying, Thomas, that that's really for the other payments other than the interim?
Yeah, so that would be for the individually assessed payments.
Yeah.
Now, they actually make up the bulk of the payments. So I think it's just over 60% of payments that are made are those individually assessed payments. And then a smaller amount would be the, well, they're not interim payments anymore, but they are the more kind of, I don't want to say straightforward because I don't think that's, but they kind of that more immediate one. And then there are a very small number of payments that can be made for next of kin of survivors who've died. So there's a small number of those, but most people will ask for an individually assessed payment.
Okay, so I noticed in your paper you said that payments are escalated for people aged 68 and above and people who are perhaps terminally ill.
Yeah.
So there is there are facilities made for posthumous payments then, in the event that someone has submitted a claim and they've since died before the recommendation or the money's been awarded to them.
Yeah, or they don't need to have put in an application. Next of kin can put an application in themselves if so long as that person fulfills the criteria in terms of being in an institution before the date of December 2004 and they died after that date, then a next of kin can put the application in. And then just in terms of the speed of those prioritised ones are looked at within 6 weeks of being received. Whereas the fuller ones you're looking at closer to 12 months or longer. So there's a bit of a delay in some of those.
There is, and your paper was very good. I mean, the statistics for Lambert Council were shocking, actually, in England. And I imagine it was very helpful that the religious orders and the organisations for which we're responsible for providing care are listed there. But would it be true to say that a lot of the organisations that were responsible for the care of these children then, Kate, were funded through by councils?
Certainly, in terms of if you look at the Scottish ones, which I've got a bit more of a breakdown on the organisations, but the investigations that this Scottish Child Abuse Inquiry has looked at, there's 12 wide areas. And for those, you're looking at like healthcare, the prison service. So there's a lot of kind of state bodies within that, as well as religious institutions, but also non-religious voluntary institutions and boarding schools. And a lot of those boarding schools would have been state-run rather than private. For example, for children from the Highlands and Islands. So,
Thomas, I just want to thank you for that, because I mean it's quite substantial research. Chair, I suppose what I'd like to find out, maybe we could ask the Scottish Government this, but you know, in terms of the money provided by the religious authorities, particularly the Catholic Church, I mean, with Paul Sweeney in, and it was under negotiation, a lot of flamas, to be honest, from Paul, but what I would like to try and establish is, you know, what percentage were the religious orders asked for, and again, just to try and ascertain why a set figure for an interim payment was made. But that's my questions for now, and thanks again.
Thank you, Carol. The clerk noted your suggestion there. We'll summarise at the end, because there's probably a few questions to go to the Scottish Government. Harry, please.
Okay. Thank you very much, Chair. Thank you, Thomas. On page 15 of your pages, 62 of the electronic pack, and how the application process works, and working from box 1 where you start your application down to box 7, Thomas. I'm just wondering, when it says accept or reject offer, do you know how many people would have rejected the offer, and what's the next steps for them? Would you have any idea on that?
So yeah, you can ask for a review, which is, well, you can reject the offer and say, I don't want it and I don't want you to look at it again. No, I think it's a very small number of people who've done that. It's something like, let me see here, 2% of offers weren't accepted and they asked for a review instead. So looking at like in the number 30s in terms of the number of actual individual applications. Of those, most of them, they varied so they did change the decision once it had been reviewed. It will go back to Redress Scotland, and a different panel will look at it alongside why the survivor has said that they're not accepting it. But the vast majority of people are accepting the offer that's made.
It just seems strange to went through the whole process and to not accept, and obviously there's good reason on their behalf, but something been worth chasing up on. Interesting. Yeah. Thank you, Thomas. Thank you.
Okay, thank you. Timothy, please.
Thanks, Chair. Another good piece of work, Thomas. Great paper, plenty of information on it. But like other members, I'm astounded by the great evil that's went on right across the UK. It's our shame, essentially, that this was allowed to happen for years, and that in each government's case, it's taken so long to get to this point. Picking up on some of the Scottish redress scheme regarding the investigations. So there's 12 wider areas. So when it looks at the Roman Catholic orders, that would include priests and nuns, is that correct?
I believe so. I'm not sure exactly what those investigations are. They haven't kind of published loads of details so far on what all the investigations have been, but I would imagine my understanding is, those are the wider areas, and there are, within that, there will be individual investigations into either specific schools run by those orders or potentially specific people, but I don't know exactly how much that's happened.
And then presumably when it deals with the Church of Scotland, that would be ministers and anybody that be engaged in child work will come under that bracket as well. And where I'm going with that line of questioning is gaps that we have in Northern Ireland. You know, you have your clerical abuse, your priests, ministers, and as well as that foster care. So Scotland, for some of its negative points regarding how long it's taken to get to this, the scope of their investigation is taken in a broader picture, and it's a broader picture than we have here in Northern Ireland. And essentially, if you were doing it again, these would be additional areas that you would be looking at.
And it will be interesting to see when the Child Abuse Inquiry in Scotland does produce a kind of final report, whether it may recommend another redress scheme specifically for one of these other areas, or people who haven't been eligible for the current redress scheme. You know, as you say, foster care or boarding schools, maybe a particular subset of those they may recommend. I'm not saying they will. I have no idea what they will do, but it will be interesting to see whether that's covered.
Yeah, and 22 organisations that's published in the list. It's interesting to see Bernardo's and the Sister of Nazareth I mentioned there, and that obviously relates to our own ongoing. I think it's a very good general rule of thumb they have, that the Scottish Government will fund 10,000 or 1/3 of each case, individually assessing payment, whichever is greater. You know, we have something in black and white of how then payments are being funded, whereas when we've had some people in front of this committee have been talking about, you know, is it profitable for organisations? And to be honest with you, that's done more harm to victims. Some of the language that's been used in the woolly approach taken to the religious orders, instead of somebody thumping the table and saying, this is our terms of reference, this is what the government's going to pay, and this is what the institutions are going to pay. Following on from Carl's comments, very much in agreement with that. So 22 institutions, a lot of them of the state, 122 million. I would like to know how much is the religious institutions making up of that. Are they coming to the plate? Is there something we can use there to say, when it comes to Northern Ireland, well, this is what they're funding in Scotland, we would expect the same here?
Yeah.
Whereas to date it's been almost, we're going with a handout, oh, what can you afford to pay us? Whereas it's the wrong way about we're going in Northern Ireland.
So on that list on the website, I didn't put them all in here because it was already becoming fairly unwieldy, but on their list of all the contributors and the kind of page that they have their apology, some of them will say the amount that, if there's a cap, it will say what that is. So if it's useful for the committee, I can go through those 20 odd organisations and tell you what each one says, and therefore if you're having a conversation with Scottish Government or whoever later down the line, if that's helpful to know how much is on there, then that's quite straightforward. I'm happy to do that.
And regarding the 92 million that's cost to date, am I right in saying from the paper that all that cost has been absorbed by the Scottish Government in the same way as the executive essentially is absorbing?
As far as I'm aware, yeah, that's
like for like.
It's the Scottish Government's investigation, and it's them that's paying for it. Yeah.
And then final thought on it really is that they seem to be a lot further ahead of extracting money out of the organisations, whereas the executive seem to be paying it all up front, and then recouping that money seems more of an afterthought, whereas the Scottish Government seem to be more in the front foot. And certainly if we were doing the redress scheme here again, and we had the opportunity to feed into the redress or the terms of reference, you know, we need to be more robust with these institutions, making sure that they're paying their fair share. Yes, they are responsible for some of this, but certainly not all.
Yeah, it would be interesting to see, if you're speaking to the Scottish Government, exactly how they've how they went through that process. I think it would be really interesting for sure.
Okay, thank you very much, Thomas. Appreciate that. Okay, members, there were quite a few issues there. I suppose just to pick up on your last point there, Timothy, with the redress scheme for the Mother and Baby institutions, there's certainly learning there, so that it's not an afterthought, you know, with the next redress scheme. So, do you want to recap on what we've agreed, please?
Yes, actually, just before Thomas leaves.
Oh, sorry.
It's just to ask Thomas to send. Sorry, Thomas. That you would send the additional slide to the committee office. Thank you.
Thank you very much, Thomas.
And that's the first thing. So, just to pick up on what's been said. So, Sinead asked for looking for further information about what fair and meaningful means, as in how they made a calculation or what guidance and so on, what formulas or guidance or calculations or modelling they did in terms of what was meant by fair and meaningful. The second thing then is how this figure of £10,000 was established. How did they reach that? And more information about the modelling. And Thomas described it as being preliminary modelling that was adjusted as decisions were made. The modelling became slightly more firm in terms of figure work, so that those figures would move. So perhaps about that process as well as the modelling, if I'm
And
understanding
also
correctly.
as well, he mentioned that caps in some areas had been agreed. What were the terms in which a cap could be agreed?
Yeah.
Because I think that that's really important as well, just that we understand the difference between ongoing and that capped fund.
I suppose the last thing I think we do need to be asking is whether they've factored in a contribution towards the specialist support services. So that's something that the groups have said, you know, the ongoing sort of counselling, for example, long past. I think they've talked about it for 10 years here, but I think that the victims and survivors have said actually people may need this their entire life. Go ahead, please, Stuart.
I was just going to say, also just in terms of the money that institutions are paying, does all of that money that's paid over go to compensation to the individuals, or does some of it go to the actual cost of the inquiries and the government processes? I mean, if you're recovering money for victims and survivors, is it not also right that you should consider recovering money for the state as well? Although the state is arguably culpable in other areas through some of its issues, but in modern terms of delivering an inquiry, surely those that are perpetrators should also be making a contribution towards the cost.
Correct.
After all, that happens in court.
Chair as well, Thomas said that he had another page where he had the 20 organisations listed and he had the figures along that. I think it'd be really helpful if you shared that with us as well, just to give us a good indication when we're going forward and taking evidence from others that we have something in front of us, and it'll help us understand even the response from the Scottish Government as well when we have it in front of us.
Sorry, just before we go on, Carol raised a couple of points. I just want to make sure that I'm not missing any of that. So Carol said a list of the amounts provided by organisations, including those from the Catholic Church. So I think that comes back to the list that's on the website, if I'm understanding you correctly, Carol. And then what percentage were organisations asked to contribute? Again, if I just want to check.
That's correct.
That's correct, okay. And again, why this £10,000 was agreed as a figure for an interim payment. And did I miss anything else? Did you have anything else you wanted to follow up? No? Okay. Thank you. If it's okay, I will put together a list and we'll circulate it and members can just have a look again and see if there's anything additional. Sorry.
On that one, I had asked the query regarding Roman Catholic orders. Does that include priests and nuns, and the Church of Scotland? Does that include ministers and any of those deemed in charge of childcare work? It would be good to know, because that's where potentially we have gaps in our own inquiry.
So basically, for the churches, does it include religious?
Yeah.
And those in charge of child care, children?
Like children outreach, child outreach.
So anybody engaged with working with children and young people?
There's one other issue, and it relates to perhaps the inquiry phase. I was reading some of the background to the Scottish inquiry, which is actually ongoing at this point in time. They've had a number of challenges to various rules that they've set down, which I'm sure sounded good at the time when they set the rules, but they're now facing challenges in them. One is around anonymity. One individual, you have a right to anonymity, but you also have a right to have your name published. But one individual changed their mind, and the panel then said no, you couldn't do that. That has unfortunately led to a very serious situation where suicide occurred. So I think that's something which we need to be careful to match, that we learn the lessons from other. I'm not saying that Scotland's done something wrong, I'm just saying that it's important that we learn the lessons from things like that, unfortunately, that happen.
Our own inquiry. Okay, members, thank you.
Yes,
okay,
thank you.
let's move on now to correspondence. So just refer you to pages 91 to 95 of your pack for the summary of committee correspondence, and just want to draw your attention to a number of items. So 8.2, Relatives for Justice Victims Payment Scheme. So page 96, 97, you'll see correspondence. So Following their briefing session with the committee on the 26th of February, they have provided the committee with an update on the work of their organisation and issues around the Victims Payment Scheme, and they have submitted a request to brief the committee specifically on that Victims Payment Scheme. So I'm just asking you to note the correspondence and then seek your agreement to schedule an informal meeting, first with myself as chair, deputy chair, and the clerk with Relatives for Justice, and then we can update the committee once it's taken place and decide on any further action. People content? Go ahead, Carol.
Sure, I prefer if they come from committee.
Okay.
Because I suspect that, you might hear this from Wave and other organisations, that the issues that they're dealing with in terms of victims' payments are cross-cutting right across the board. So I do think it would be helpful if they came in front of the committee.
Okay, go ahead.
Yeah, following on from the European Day for Innocent Victims, there's a number of the contributors on that day had raised this as an issue during their testimonies. I think of Pamela Wilson and Caroline Death. Caroline Death, from memory, it was a case of once her father was killed, the mother then had to take up that role of being the breadwinner. Mm-hmm. So in that, she had to go out and work 2-3 jobs to provide for the family. So it just didn't impact somebody that's seen the atrocity. There was a ripple impact right throughout the family, and that family, I do believe, should have been entitled to the payment. And there's a couple of testimonies from that day. I would be happy to come in front of the committee, Relatives for Justice, and anybody else that feels they can add into that and add strength to that argument.
Okay, so I suppose it would be useful then, if members are in agreement, we asked the clerk and her team then to look at a panel to look specifically at the Victims Payment Scheme. If you could supply the information and anybody else put forward suggestions for any organisations that they think you would have representatives who would be across the detail on this. Is that okay? That sound reasonable?
Is everybody content? Yes.
Mm-hmm.
Okay, thank you everyone. So 8.5, the Executive Office Common Framework. So this is found on page 125 to 129. So this correspondence has been received from the Department in relation to outstanding common frameworks. The Executive notes that work has been undertaken on 32 common frameworks which all apply to Northern Ireland, most of which are operating on a provisional basis until fully finalised. It is anticipated that the majority of the common frameworks, those that have completed scrutiny, will be implemented in final form by spring 2025. So a full list of the frameworks and the stage at which they are at is included in tabular format. So I just want you to note the correspondence and seek your agreement that to include this item as a relevant paper for the oral briefing on EU matters with the departmental officials on the 30th of April. And also, as you may recall from previous correspondence we've received in relation to common frameworks, I've asked for the committee's permission to send this to the Interparliamentary Forum, so the UK-wide body that is looking into this, and also the EU Scrutiny Manager, Shauna McGahan, who again has come before this committee several times and discussed these, and also the Chair of the Finance Committee, who also attends the Interparliamentary Forum with me. Are people content we share this update?
Mm-hmm. Great.
Okay, go ahead,
A couple of
Timothy.
queries in this one, or comments maybe. So on page 125, framework highlighted in bold requires agreed Windsor framework text to be included in order to complete the finalisation process. Is it possible ahead of anybody coming to committee that we could get the drafts before the Windsor framework information was submitted or included? So it means we would have the drafts pre-Windsor framework and then a draft or the final version after the Windsor framework information has been submitted. I would have queries regarding who provides the text. Does it come from the EU? Does it have to be approved by the EU? If it comes from the EU, who sends it? If it has to be approved by the EU, who approves it? Why haven't we already seen it here?
So the common frameworks are just within the UK in terms of how they deal with some issues that before would have been governed through the EU. So,
but you can see from the text in bold, requires agreed Windsor framework text to be included in order to complete the finalisation process. So there must be something buy-in from the EU. and that's why I'm saying I would like to see these prior to the Windsor Framework text being inserted or included, so there's a comparison of how the Windsor Framework has amended some of these common frameworks and the impact that they have.
Ask the department. It's okay. Go ahead.
I was just going to say that I'm not sure I know enough about what that means.
Right.
That frameworks highlighted require Windsor Framework text. So I'm not sure I know enough about what that actually means to be able to go ahead and action that. So can I suggest that I go back to the department on behalf of the committee and ask for an explanation as to what that means? And that session we're talking about later on is in a number of weeks' time, that we would bring that information back and we can clarify it and just so that we can understand how to action what you're requesting.
And that's why I'm highlighting it today, that it's not a case of somebody coming in front of the committee. We're asking these questions as has been too frequently the case, where I'm not sure, I don't know, would need to come back to you in that. And if we could provide these questions in advance, I'm happy that they provide some clarity, because there's obviously an element of EU approval, EU information that's gone into this.
Supposition, no.
I think. Oh, sorry.
Sorry, I was going to say we could ask about the process
Yes,
to explain what that process is, so then we're clear about what we're asking for and what that list actually means then.
I also think that lady, Shauna, the EU scrutiny manager, would say she's very across the detail on this. So she'd be another one to.
It'll be interesting if the new text requires new obligations. If it does require new obligations, who does that fall upon? So there is a number of queries that I think we'd like to thrash out before anybody would come in front of the committee.
Yeah. Okay. You look into it,
Yes.
please. Thank you. Okay. So 8.9, Committee for Communities, Housing Supply Strategy and Anti-Poverty Strategy, and I note your declaration earlier, Brian. So we'll refer members to page 210 to 212 of meeting pack. So just to advise you that the Committee for Communities has written to the head of the Northern Ireland Civil Service to request advice and views on the most appropriate route to effectively support both the Minister for Communities and the Minister for Infrastructure in prioritising progress on the building of social housing. The committee is also seeking a view on the recent court judgment which stated that the responsibility for the anti-poverty strategy lay with the executive. So just ask you to note this item of correspondence and that the committee will be included in any reply. Any thoughts on that?
Chair.
Go ahead, please, Carol.
So I noticed the judgment said that the responsibility for the anti-poverty strategy lies with the executive committee. But if the minister hasn't brought the anti-poverty strategy to the executive, I'm unsure about that, which led me to query where are the other strategies that the Minister for Communities is responsible for example, like disability, racial equality,
Andrew.
Sexual orientation, all those. So I mean, could we write and try and find out where they are, because I mean, I don't understand how our committee is responsible for anti-poverty when the minister hasn't even brought it forward. It just doesn't make sense to me.
Mm-hmm. No, that's a fair point. Okay.
More information is required.
Yes.
Yeah.
Okay.
Chair, sorry. Did you mention 8.7? Sorry,
No, I'm making. Oh, sorry. No, go ahead.
The Executive Office response to the Committee for Economy regarding the North West Development Fund.
Yes.
I would really like an update on that. Okay. Now, there is a letter there stating the obvious, that match funding hasn't come forward to the North West Development Fund, and the ROI government. They have put in 1 million additional money that hasn't been match funded by the Northern Ireland Executive in order to keep the structures open for the next tranche of funding, hopefully coming forward. They have made a further payment of €122,000. And no match funding has been made out of the Executive Office, and no reason. They've just stated what has happened, which we all know what has happened, that they haven't made any match funding since the first funding came forward, which was 2.5 million euros. So I want to know why they haven't made any contributions. And they give no explanation as to why. They've just stated what has happened, and I would like to know why. That they haven't done so.
Members content we write to the department to ask that question? Okay, thank you.
And actually to come forward, maybe we can give an update of the work of the Northwest Development Fund and what the procedures and the going forward in order to ensure that the structures remain in place.
So if we ask them for a written briefing in the first instance, is that the correct process then, and then with a view then that possibly invite them? Okay, so just going back then, 8.10, Committee for Finance, the final 25-26 budget proposals. So just refer you to the pack on pages 213 to 217. So just to advise that the Department of Finance is seeking information from departments to inform proposals on a final budget for 2025 to 2026. These will be brought to the Executive following the close of the overarching Department of Finance consultation on the 13th of March. The aim is to have a final budget agreed in advance of the new financial year. So just seeking asking members to note this correspondence and seek agreement to write to the Department to request that the Committee is sent a copy of any further information to inform final budget 2025-26 proposals once they have been sent to the Department of Finance. Carol, do you want back in?
Yeah, Chair, see on page 215 of the finances paper, it talks about sorry, I get it back again. Yeah, financial transactions capital. It says that there's 8.4 million of unallocated FTC available for 25-26, and it's asking departments to submit requests for additional FTC. Could we get just some more information on that? Because my understanding was FTC is used for co-ownership, but I'm not too sure what else it's getting used for, so we could ask for more details on that, please.
Okay, yes, thank you. I think a statement came out on co-ownership today, so there might have been something
embargoed until tomorrow.
Oh, it's embargoed until tomorrow. Go ahead, Brian, please.
I'm not sure if it's used for. It's used for intermediate rent. That was the recent announcement. So I'm not sure if it's used for co-ownership as well, but that was the recent. The Communities Minister announced it was intermediate rent. My understanding is it's a loan that ultimately has to be paid back. But it'd be useful to get, even if we could get a presentation on FTC, because it's. I don't have a clear understanding of how it works myself. You know. My understanding it's a loan and it goes into privately funded initiatives to enable them to happen. And so the funding is like a government subsidy to enable these intermediate rents at 80% value to make them affordable. But just, all the criteria around that, both for securing the loan and then how that enables, as I say, the reduced rent to be provided. I would be interested in getting a proper briefing on that. Maybe other members would as well.
So next week we have the TO briefing on the budget, so I'm just wondering if we could ask them as part of the papers that are submitted that they could provide a bit of a narrative in relation to FTC. And then we can ask them about it, but it'll give us time to process it before.
The letter that went after the committee considered the written paper last week included the question about the breakdown for the FTC and what was included in it. That was just for TEO's discussion about FTC, but we can ask them for a slightly broader understanding for it after today's meeting to see if they can speak to that next week.
Okay, so members, just want to read into the record then, just to advise you to note the following other items of correspondence. So item 8.3, Hansard report of the draft refugee strategy and delivery framework departmental briefing which took place on the 5th of March this year. 8.4, Hansard report of the programme for government departmental briefing which took place on the 5th of March. Item 8.6, the 34th report of the Examiner of Statutory Rules to the Assembly and appropriate committees. There were no rules for the attention of this committee. The next item there was the North West Development Fund. We've noted your question and request there, Sinead. So item 8.8, correspondence from the Northern Ireland Fiscal Council, who have published its assessment of the Executive's 25-26 draft budget for Northern Ireland departments, and included is a press release and the report. Item 8.11, press release from the Executive Office on the report Ending Violence Against Women and Girls, Experiences and Attitudes of 16-year-olds in Northern Ireland 2016. Item 8.12, the press release from the Executive Office following the Deputy First Minister's address to the annual Northern Ireland Bureau breakfast event in Washington DC. So there were a number of other items that we didn't read into the record last week, so if you'll bear with me, members, I'm going to read these in now. So item 8.13, correspondence from the Executive Office regarding seasonal agricultural workers and visa recommendations. Item 8.14, press release from the Executive Office in relation to the competition for language commissioners being launched. 8.15, press release from the Executive Office regarding individual wellbeing statistics in Northern Ireland 2023-24. And item 8.16, correspondence from the Committee for Finance in relation to the capital easements highlighted in the spring supplementary estimates as a result of ongoing legal challenge. Anybody else want to raise anything else in relation to correspondence? No. Okay, well, just moving on there to item 9 then, draft forward work programme. I'll refer you to page 230 of the pack. And just to advise members that the Assistant Clerk will talk through the changes to the forward work programme.
Thanks, Chair. Just a couple of things. So for the meeting next week on the 26th, obviously the SR is going to come back for formal consideration when the Examiner reports on Friday afternoon. And then we also have an additional briefing from department officials on the 25-26 budget. And as the Clerk's indicated, that's the 13 queries that we sent off after last week's meeting for them to answer. And the only other change is for the 2nd of April. Survivors Together have moved to that date, and that was just due to their request due to personal reasons. So that's just been rescheduled for the 2nd of April as well.
Okay, thank you. Anybody else? Anything else in relation to the forward work programme? No. Okay, thank you. Okay, any other business, members? No. Okay, so we'll just adjourn the meeting now, and same time, same place next week. Thank you.
Committee Room 30, Sound.